Okay, well, we'll get started on time then. Thank you for coming to Marion University's Constitution Day event. It's in honor of the signing of the Constitution on September 17th, 1787. And because you came, and if you make it through, we will give you one of these, your own personal Constitution, as a reward for showing up. Thank you for the people listening on Zoom, too. We appreciate it. Before we get started, I'd like to introduce my colleagues who are going to be conducting this with me today. First, we have Dr. Rick Almeida. He's been at Francis Marion since 2007 and earned his PhD at the University of Missouri. Dr. Dylan Tatum has been with us since 2016 and earned his PhD from George Washington University. Dr. Kyle Morgan has been with us for 4 weeks, and he earned his PhD from Rutgers University. Dr. Lauren Perez has been with us since 2019 and earned her PhD from the University of Pittsburgh. My name is David White, and I've been here since 2000, and I earned my PhD from the University of Arizona. Special thanks to Dr. Tatum and Dr. Perez, because their expertise is international relations and comparative politics. To let me drag them in here, I appreciate that very much. So let's talk about amending the Constitution. That's what we're going to do today, and we're going to offer some proposals that may or may not help our democracy and our government. So in Article 5 of the Constitution, first of all, the process is a two-stage process, and the first stage is the proposal stage. An amendment can be proposed by either 2/3 of both the House of Representatives and the Senate, or 2/3 of state legislatures that request a convention, a national convention convened by Congress. For South Carolina, our state legislature is called the General Assembly, and it's based in Columbia. Today, with 435 representatives and 100 senators, that 2/3 threshold would be 290 representatives and 67 senators, and it would be 34 states. So the second stage is ratification. And the first thing I want you to notice is that we went from a 2/3 threshold to a 3/4 threshold. They're different things, but that's higher, and it's tougher to surpass that. Having said that, I want to tell you that in the Articles of Confederation, which was our first constitution, any amendment required unanimity, so all 13 states had to agree, so this actually is a little bit easier. And what did you do here? You either have 3/4 of state legislatures or 3/4 of state conventions. So there it is, 4 possible ways to amend the Constitution. Out of the 27 amendments to the Constitution, 26 happened this way. Only 1 happened this way. So that's the one I'm going to talk to you about for a moment. Okay. The amendment that passed this way was the repeal of prohibition, the 21st Amendment to the Constitution. Okay. The 18th Amendment to the Constitution was prohibition, and there's the language of the first section up there. But by the 1930s, there was clear support, public support throughout the country to repeal prohibition, which is one of the reasons that the Wets, the people that supported the repeal of prohibition, wanted to use state conventions. Okay? For one, they worried about state legislatures that were dominated by rural states and rural representatives, because they still wanted prohibition. So by using the state conventions, they could bypass that. They also knew that public opinion was with them. And this is an amendment that was proposed in February of 1933 and ratified in December. So you can tell that there was a lot of support for it. The Dries, the people that were still wanted prohibition, were actually okay with state conventions. Because if you left it to state conventions, then it meant they didn't have to deal with a divided issue in the state legislature. So they were actually for using this. And I should add that both the Republican convention in 1932 and the Democratic convention, the presidential conventions, both of them were supportive of the repeal of prohibition through state conventions. So this was really a nonpartisan issue. There were lots of Republicans and lots of Democrats that supported repealing it, but then there were some of each party that also wanted to keep it. It was really sort of a rural versus urban issue, and urban areas wanted to repeal prohibition. So how did it finally happen? There were only 48 states back then, so you needed 36 for approval. Louisiana, Mississippi, Georgia, Kansas, and North Dakota didn't even hold state conventions, which suggests that they weren't supportive. The two states that voted against it were North and South Carolina. But it succeeded, and that's where we're at right now. So now I'll turn it off to Dr. Almeida.
Good afternoon, everybody. So I am here to talk a little bit ultimately about a suggested reform, but I want to start a little bit by kind of something we've been really kind of focused on in my intro classes this week, which is the idea that drafting the Constitution and ratifying the Constitution was a really difficult and divisive decision for the U.S., right? You know, it created a much more powerful government than the one it replaced. And that might seem a little bit odd because we celebrate the Constitution as creating a limited government with checks and balances. And that's completely true. But it also was much, much more sweeping in power than the Articles of Confederation had been. And embedded into the ratification and passing of the Constitution was the idea that in order to get enough political support to ratify it, there were going to have to be kind of almost immediately a package of amendments, a package of changes. From history, I imagine most of you remember the Anti-Federalists, and they were concerned about a variety of things, a lack of a Declaration of Rights, a Bill of Rights, but also the fear that if a series of rights were explicitly listed, somebody would argue later that those were the only rights guaranteed, right? And so, there really were a lot of choices to be made, about how to amend this, and 12 proposals come immediately after the ratification of the Constitution. Interestingly, the latter 9 of them, Articles 3 through 9, wind up becoming the first 10 amendments of the Constitution. The stories of the two one of which made it a little bit later and one a little bit lost to the sands of time, the stories of those 2 amendments that didn't quite make it early on are pretty interesting ones and set the stage for what I really want to talk about, a proposed amendment of my own. Pardon me. Article 2 winds up becoming Amendment 27 to the Constitution in 1992. It was proposed in 1791 along with the other ones, but it doesn't get ratified until 1992. 6 states ratified it right away, and then interest in it really kind of trailed off. In 1982, an undergraduate political science major at the University of Texas named Gregory Watson writes a paper in an American government class that, based on his reading of this proposed amendment, it could still be adopted by the states. That when this package of 12 amendments came out, it didn't set any time limit on when they had to be ratified. It just so happened that 10 of them got ratified very, very quickly. He got a C on the paper and it made him mad. The teaching assistant who graded the paper said, it's a cute idea, but it's really not viable. And he disagreed. And so he took his C and he started a letter writing campaign to all of the state legislatures, urging them to adopt this amendment. And less than a year later, the first one does, Maine. And as soon as Maine adopts this amendment, which hadn't really been thought about much since 1791, states begin to race to ratify it, and it came down to a last-minute battle between Michigan and New Jersey to see who could ratify this the fastest in order to be the deciding one. And so now let's talk about the one that's left, right? And it's the, and it's the one that most directly sets the stage for what comes next. The one that's left, Article 1, and I guess I should point out that the folks who put this package of amendments together must have put them in some kind of order. And, a historian would probably speak better to this, but it is kind of interesting to me that the one they listed first is the only one that didn't wind up becoming part of the Constitution. It's an amendment that would have set a minimum and a maximum for the size of the House of Representatives. And that may sound like that is a pretty sort of minuscule, arcane thing, but it does speak to a thing that the United States has wrestled with from its very beginning. We're here to talk about amending the Constitution, and there are myriad ideas about what ought to be fixed and how. You'll hear a bunch of them from my other colleagues. I personally think Congress could use some fixing. And I'm talking about structurally. The American people elect good people to Congress, they elect not so good people to Congress, and everything in between, and that's all by design. That's democracy. But some of the ways the institution, the body is set up, just don't do the job as well as they could. And I think herein lies one. The House of Representatives, the Constitution doesn't say anything about the size of the House of Representatives. This amendment would have set a minimum and a maximum, and it proceeded by a couple of steps that aren't important. But basically, if it had been ratified, it would have set a minimum size for the House at 200 and a maximum size of one representative for every 50,000 Americans. Now, folks, there are about 330 million of us in the country today. And so if this amendment had passed, the maximum size of the House of Representatives would be about 6,600 people. You can argue that Congress ought to be bigger than its current 435. I don't think anyone would say that a 6,500 person House of Representatives was a recipe for anything good, right? But this is one of those unanswered things. But I do want to take a pretty good swing at reforming Congress, and I want to do it in a way that hopefully will advance a slide. That will do it in a way that will eliminate the practice of gerrymandering, another practice that is almost as old as the United States itself. Gerrymandering, as you see, is the practice by which somebody draws legislative district boundaries in order to benefit a political party or some other group. And gerrymandering is bad. We don't often make sort of value judgments like that in political science, but gerrymandering is generally not a good thing because, as you see, gerrymandering deflects from what the voters arguably really chose. That's a statement that's a little bit fraught with peril. I don't mean anything metaphysical. I mean something simply rather numeric. And by example, consider the last two congressional elections in our next door neighbor, North Carolina. In 2018, North Carolinians voted for their House of Representatives candidate like people all across the country. In 2018, Republican House candidates in North Carolina got 50.4, in other words, just about 50.5% of the vote statewide. Those Republican House candidates, on the other hand, won 10 out of the 13 possible races. They got 50% of the vote, but they got 77% of all of the available seats. And either these were the best possible candidates that the North Carolina has ever served up, or there is something amiss in the process. You know, a little bit in the abstract, what we want to look for is the degree to which the percentage of votes a party gets matches up to how much of the elections or how many of the legislative seats they win. And arguably, in an ideal system, those should match up identically, or at least really, really close. If 50% of the vote gets you more than 75% of the seats, something is wrong. And that's gerrymandering. North Carolina was taken to court over its legislative maps. A court intervened, ordered the state of North Carolina to redraw 2 of its districts. That's the map that went into the 2020 elections. In the 2020 elections, Democrats slightly outperformed Republicans statewide. Democrats got exactly 50% of the vote. Republicans got 49.6%. But under the new maps, Democrats won 5 of the 13 seats instead of their previous 3, right? Arguably closer to the seats to votes ratio that they earned, right? Gerrymandering is generally a pretty bad thing. And that's easy to say. And like so many things in government, it's hard to fix because it really does require us to ask what a legislative district should look like. You know, there is this baseline that the district should be kind of microcosms of the state that they are in, right? That if nationwide a state is 53% Democratic or Republican or whatever, that should yield 53% of the seats in Congress that are available or what have you. But you can make other arguments that are rooted in connecting communities or maintaining communities and where you draw those lines to, reflect important linguistic and cultural and religious boundaries or what have you. This is a necessary process that is necessarily and unavoidably fraught with peril, just even from the sense of defining what it is we are looking at. And in the United States, a significant majority of the authority to draw these districts lies with state legislatures. 33 of the 50 states allow their state government to decide where these boundary lines are. And those states, of course, have a Republican majority or a Democratic majority, a Republican governor or a Democratic governor. And those actors try to use this process for the maximum political effect, the maximum partisan effect. 8 states have taken this power away from the elected branches of government, invested them in commissions that are designed to be balanced, that are designed to be nonpartisan, which pretty arguably is a step in the right direction. But maybe we can just take people and politics out of it altogether. Right? Maybe what's desirable is a process that really just can't be manipulated. If the goal is to divide a shape into pieces of equal size, these are things that mathematics are really well suited to do, and to really kind of look at shapes and divide things and make things that look a certain way. And there is a very straightforward, entirely mathematical way of dividing the United States or any particular state into equal population districts that is really only based on drawing as short a line as possible. That's the essence of the split line method. To make it, the math is not hard, but to make it really short, basically you take the number of seats that a state is going to get. South Carolina's got 7, so it's a perfect example. We need to divide South Carolina into 7 pieces of equal population. The split line method tells us that the way you do that is to, 7 boils down to 4 plus 3. So you divide South Carolina into a chunk with 4/7 of the population and a chunk with 3/7 of the population. And you draw that line just based on whichever one is the shortest to get you that number. And then you keep repeating that process of drawing the shortest state line until you get however many absolutely straight lines as you need. This is the continental 48 United States divided up into split lines. If you looked at the real electoral map of the United States, it would be a monster of squiggly lines and carve-outs and what have you. This almost looks like a proverbial sort of Iowa farm field, right? It's got nice straight lines, it's perfectly even, everything balances out. And since there shouldn't be any political bias in where these short lines happen to be, there's really no opportunity for any sort of outside actor to manipulate this process for their own ends. And the American people would finally have pretty fair representation. But that's only true as far as the people who can participate, and I think that's a good place to turn it over to Dr. Tatum and voting rights.
Thank you very much. So what I'm going to talk about today, I'm looking at myself on the Zoom thing. Okay, maybe fix my hair, I don't know. What I want to talk about today is I want to talk a little bit about one potential proposed amendment related to voting rights. But to start that off and to sort of get us into thinking about what the problems are associated with exercising the right to vote in the United States, and particularly who is disenfranchised by current institutions in the U.S., I want to talk about a very important amendment to the Constitution, the 13th Amendment. And the 13th Amendment reads, it has 2 sections. I'm going to focus here on the first section of it, but the 13th Amendment says, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall be duly convicted, shall exist within the United States or any place subject to their jurisdiction. And the 13th Amendment was ratified in 1865. It is one of the 3 Reconstruction amendments, right? The amendments that come right after the Civil War. 13th was ratified in I don't know what that is that just popped up. But it was ratified in 1865. The 14th was ratified in 1868. And the 15th in 1870. All 3 of these amendments have to do with providing the context for equal rights for African Americans, newly freed individuals. The 13th abolishes slavery. The 14th provides for equal rights and due process. And the 15th provides for no restrictions on the right to vote for African American citizens. So there's 2 readings of the 13th Amendment here. One is that it creates the possibility for equal citizenship for African Americans. And of course, as I mentioned before, it's followed by the 14th and 15th Amendments, which further provide the conditions for specific rights. But it also, in that middle clause there, except for a punishment for a crime, creates the possibility of limiting equal citizenship, including things like voting rights, based on crime and punishment. And so a couple of statistics about crime and punishment in America really show us where we are in thinking about how crime and punishment limits the rights of individuals in the U.S. So right now, these are statistics from the Sentencing Project, which has compiled a bunch of these statistics about criminal sentencing in the United States. We currently have over 2 million people in U.S. prisons and jails. Since 1980, that represents almost a 250% increase. Black men are 6 times as likely as white men to be incarcerated during their lifetimes in the United States, demonstrating that the criminal justice system is institutionally biased against African American men. And related to what I want to talk about especially is that 5 million people in the United States are currently disenfranchised from a felony conviction, meaning that due to state laws in the states in which they live, 5 million people are not allowed to vote because they have a prior felony offense. And of these people, 1 in 16 African Americans in the United States of voting age are disenfranchised because of felony disenfranchisement. And so why is this important? Well, voting is a central mechanism for decision making in democratic communities, right? I was just lecturing to my class about this morning, about how democracy, one of the things that we associate with democracy is the fact that we get together every now and then, cast votes to determine what our preferences are. Impeding one's right to vote through things like felony disenfranchisement is an impediment to one's exercise of their citizenship in a democracy. Right? Telling 5 million people that are American citizens that no, you can't vote or participate in U.S. elections because you, at one time or another in your life, committed a felony, impedes that right. And so one of the questions that comes out of this, in thinking about the 13th Amendment and the Reconstruction Amendments, trying to provide equal rights and equal citizenship to African Americans, and then looking at the institutions that we have and seeing that these institutions of crime and punishment, etc., are impeding one's right to vote, impeding 1 in 16 black men's right to vote. What do we do about that? Do we need an affirmative right to vote in the Constitution? Now you might be thinking, well, we got a right to vote. I mean, I know that. I'm 18, I go out and I can go cast a vote every 2 years. But while there are specific amendments in the Constitution that address voting in one way or another, the 15th gives the right to vote to African Americans, the 19th to women, the 24th gets rid of poll taxes, and the 26th lowers the age to 18. The Constitution does not have an affirmative right to vote. As the organization Fair Vote notes on their website, while the U.S. Constitution bans restricting voting on the basis of race, sex, and age, it doesn't explicitly and affirmatively state that all U.S. citizens have a right to vote. And one really interesting thing is, the Supreme Court made this very clear in one particular case, which was Bush v. Gore in 2000, which ended the recount in Florida over the 2000 election. Antonin Scalia, a justice who has now since passed away, argued during the oral argument, said very clearly, the United States Constitution does not guarantee an affirmative right to vote for president. And so what I propose here in thinking about this question, is it time to amend the Constitution, is that maybe we need an amendment that guarantees explicitly voting rights. Now this has been proposed to the U.S. Congress in 2017. H.J. Resolution 74. This is a joint resolution to Congress. It was introduced in 2017 but never acted upon. And it says, Section 1, every citizen of the United States who is of legal voting age shall have the fundamental right to vote in any public election held in the jurisdiction in which the citizen resides. And what I think is really important and really interesting about this, and one of the reasons why I bring this up as a proposed amendment, is that we not only need an affirmative right to vote in the United States to affirm that is a right that all citizens of the United States have, but also to remedy, address, and start to engage with in a serious way how institutions of American politics keep certain groups of people from participating in equal citizenship. And on that, I'm going to hand it over to my colleague, Dr. Kyle Morgan.
All right, so I'm going to talk about something slightly different here, and instead of how we've formally amended the Constitution, how we've informally amended the Constitution, right, through judicial precedent, the role of politics. And so you can kind of think of the Constitution in one of two ways, right? There are easy questions and there are hard questions. You have to be at least 35 to be president. There's no debate over that, right? Can't be 32. This is laid out quite clearly, Article 2, Section 1. On the other hand, right, we have hard questions, right? 14th Amendment guarantees equal protection under the law. What does that mean? All right, equal protection is not as clear as you have to be 35 years old. And so the Supreme Court gets handed the power of deciding these hard questions. Easy questions are not going to the Supreme Court. But instead, right, the nature of equal protection is something that the court's going to decide. And so in 1896, the Supreme Court hears Plessy versus Ferguson. This is a question regarding, I think it's Louisiana, if right, they can have segregated train cars based on race. This is post the 14th Amendment. 14th Amendment's passed in the late 1860s. 30 years later, we're grappling with this, and the court says, it's fine. Separate but equal is okay. And so for the next roughly 50 years, 60 years, right, we're going to be stuck with separate but equal. Until Brown versus Board of Ed, 1953. The Supreme Court hears a challenge to racially divided segregated schools, and they reverse course on separate but equal, right? This had been the law of the land for 50-something years. We change this. Nothing changes in the Constitution. The Constitution is the exact same. We don't rewrite the Equal Protection Clause. We don't add anything about education, but simply, right, the courts have changed how they're going to interpret this. And so this is a lot of power for the courts, right? They fundamentally rewrote how we interpret the Equal Protection Clause. And this isn't something, though, that just the court has a say in. Oop, skip going. There we go, right? The courts have a role in this, right? We have a common law system. It's why if you take common law or civil liberties, you study precedent, right? We evolve our law through what judges do. This is their job. Their job is to resolve these hard questions, to give us some answers about how to proceed. They're not the only ones who have a say in this, right? Politicians and politics play a huge role. The classic example is FDR's court packing plan. During the New Deal era, FDR is elected, enacts a series of reforms to address the Great Depression. Many of these get struck down by the Supreme Court. They're hostile towards his New Deal agenda. In response, he says, I'm going to do something really nice for you guys. You're all old, you're on the Supreme Court, I'm going to make your life easier. For every single one of you, it's over 70, we're going to add a new justice. We'll take some workload off you, right? You don't have to raise many opinions, be way easier for you. Also, so give him a majority on the Supreme Court. And so this fails, but it's one of the serious times we see court packing, right? The threat of adding a bunch of justices really come to the forefront. Even though it fails, the court arguably backs down after this, right? We see several retirements, and we see the justices start flipping and ruling in favor of FDR's New Deal agenda more consistently. And so politics shaped constitutional interpretation. Right? The New Deal changed how we saw the role of the federal government, in part through the Constitution, right? The Commerce Clause was interpreted in a more robust way. We see a bunch of federal programs emerge out of this, and so politics plays a role. We also see nominations just through the normal process, right? Not threatening the court, changing things, right? We just had the Amy Coney Barrett nomination, right? That is going to have a huge effect on politics, right? And how the court approaches things. And the public also has a role in this constitutional conversation, in how we informally interpret the Constitution. So same-sex marriage advocates used equal protection to argue for marriage equality, right? They drew on that language, and in the early 90s, 27% of the public supported marriage equality. Most recently, it was up to 70%. And part of this was through an effort to change how we thought about marriage equality, right? We thought about it as a equal protection issue, right? That they're entitled to the same treatment under the law as anyone else. And so they capitalized on this language, and we see it then get put into informally into the Constitution through the Obergefell decision. You also see, right, Second Amendment advocates doing this as well, right? They did it through the Legal Academy, right? So in 1939, we have U.S. versus Miller. It's a gun control decision. They rule that there is not an individual right to bear arms. That's the rule of the law of the land until to the 2000s. We change, right? We have new justices by that time, and we get DC versus Heller, which finds a constitutional right to an individual right to bear arms. This came from, right, legal activists, right, academics writing in law reviews, ceding the idea that there is an individual right to bear arms, and we see this shift. And so the population has a say, right, activists have a say, all of us are engaged in this constitutional conversation. We tend to think that the court's the end of the game, but really, it isn't. And so this is sort of a good thing, right? We haven't changed the Constitution a ton, right, formally. but we adapt our interpretation over time to interpret it in light of where we're at today, right? Think of the separate but equal and then Brown. We don't rewrite the Constitution, exact same thing, but we adapted it from the late 1800s to the middle of the 1900s, right? So we just reinterpreted it differently. And this is a good thing because it's flexible, right? It allows us to not have to have a constitutional convention, not go through the complicated amendment process, and we can still function. Things don't shut down. And, right, it allows us to engage in this constitutional dialogue. On the negative side, it weaponizes the court. The court is incredibly powerful, right? And it can also shut down conversation, right? The court's ruled something, that's it. You've got to right now really work to change that dialogue. And so it can help function, it can help the conversation, it can also shut that down, and it creates a lack of clarity, right? Anybody that's in my civil liberties class knows that, right, how we viewed free speech depends, right, on what era you're looking at, right? Is it the 1950s or the 60s? Are we talking about communists or are we talking about anti-war protesters, right? Who are we talking about? And so your rights are going to depend on who's interpreting at that time. And so that's not necessarily a great thing, right? We're going to have to engage in these complicated legal fights. We turn political questions into legal ones instead of just having the policy fight outright. And so this is, right, I think, problematic. And so this incredible power of the court, right, this kind of ability to cause confusion on one hand, right, to end debates on the other, I think isn't really where we want to resolve these issues for, right? A lot of the other presenters I've talked about, right, expanding democracy, increasing access, the court doesn't do that. And so instead, maybe we need to kind of curtail the court. And so my proposal then is going to be about term limits, right, for judges, particularly federal judges, because we can change that. And so the Constitution says that you serve for life. If you have been appointed and confirmed as a federal judge, any of you today get confirmed, congratulations, you have a job for life. And so at the Supreme Court level, if you're, right, today, and, right, Amy Coney Barrett's going to be there for probably the next 30 years. I will be nearing retirement by the time she leaves the Supreme Court. Most of our lives, she will be there. Whether you love her or not, that's a long time for one person to be able to make these decisions, to guide how we interpret the Constitution so heavily. And so I think we need to de-weaponize the court. And so how we could do this is just by making term limits, right? Regular appointments, every 18 years, we're going to replace one of the justices. And you can set it up, right, so that you're not coming back, you don't get to another stab at the job, you have to retire. And so this serves the purpose of reducing the gamesmanship that we saw around Amy Coney Barrett, right, rushing the nomination through right before the election. We saw this with Neil Gorsuch and Merrick Garland in 2016, right? Take that off the table. That's not good. That doesn't help the court's legitimacy because you seem just blatantly political. And so if you make it on this regular appointment, we don't have to go through this fight. You can appoint who you think is going to be best. There's not a rush to appoint people who are younger and younger. Right now, we've seen the age of justices decline. Amy Coney Barrett's historically young. Biden's going to follow the same trend. He's going to appoint someone who's going to be in their 40s too. Because why would you appoint someone in their 70s? They might be great, but they're only going to be there for 10, 15 years at most. So this will allow you to, right, appoint qualified people, not have to worry about finding someone who's young. And it also, right, improves our fairness of our system. If we're going to have the court resolve these complicated political questions, right, these philosophical moral questions, we want to have some trust in that institution. And right now, right, if you like the group that has captured the court, you love what the court does. On the other hand, right, the luck of actuarial tables, right, when people die, shouldn't determine what constitutional rights you have. And so by setting up this process of replacing people every so many years, we can increase the court's legitimacy, right? I don't think that the appointments are just nakedly partisan, or I do, but right, I trust the fact that, right, it wasn't just the luck of the draw, they stacked the court in the middle of the night, and so this would help kind of accept what the court does. If the court's going to be engaged in these things, right, if it's going to resolve these questions, at least we should trust it. At least we should have some confidence in that institution. And so this might be kind of small potatoes to right to vote, drawing districts more fairly, things like that. But the court, right, has resolved most of our major social questions. Think about one the court hasn't touched. And so we should have more confidence in that institution. arguably the current system where, right, you appoint a 30-year-old, they're there for 50 years, isn't a great system, right? The current justices write with quills and parchment sometimes. They're resolving questions about the internet. They don't use the internet, half of them, right? We've had to pressure some of them to get phones in their house. Maybe, right, we want to replace some of them over time before they become so out of touch with society that they're writing with quills and parchment. So on that, turn it over to Dr. Prez.
All right, thank you very much. There we go. Okay, so I'm going to start out by talking about the Equal Rights Amendment, which is kind of probably the most famous example of a failed amendment, and I'll talk briefly about a couple of other failed amendments. And then I'm not sure that my two halves segue quite as nicely as some of my colleagues, but perhaps I will go with, I'm pretty sure that my proposed amendment would fail, so that can be the connection between these two parts. So the Equal Rights Amendment was first drafted in 1923, all right, and eventually gets approved by Congress in 1972, all right, and the basic text of it says, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex, right, and it goes on to say that, you know, the federal government can pass laws to make sure that that happens. And unlike the amendment we heard about before, right, that took 200 years to pass, this one had a deadline. So it said that it needed to be ratified, or not to pass, but to be ratified. This required ratification by 1979. And then when that looks like it's not going to happen, Congress comes back and extends that deadline to 1982. All right? And so they need 38 states to get it ratified. 30 states right out of the gate, in the first year, ratify the amendment. It's looking pretty good. But the conservative and religious right starts to ramp up opposition to this amendment. And we see that only 5 more states ratify it by 1977. And then 5 states actually try to revoke their ratification. Okay, they pass laws saying that they are going to rescind their ratification votes. And then nothing happens with it, right? So by 1982, we don't have the 38 ratifications that we need, and it seems like it's dead. And then with Me Too movement, suddenly people start talking about the Equal Rights Amendment again. And some people start talking about passing a new Equal Rights Amendment, and it has been reintroduced into Congress pretty much every session of Congress. But Nevada starts and says, you know, let's just go ahead and ratify this. It's the right thing for us to do. And so they ratify it in 2017. Illinois follows suit in 2018. And then Virginia comes along as potentially our 38th state in 2020 and ratifies it. Okay? Which raises 2 constitutional questions that are still somewhat unsettled. So one question is whether Congress could now change or remove that deadline, right? So those deadlines of 77 and 82 were set by Congress. Could Congress pass a law now, or a resolution now, trying to change that deadline? And this has been introduced into Congress a number of times. It has passed the House in both 2020 and 2021. And there is a resolution in the Senate that has bipartisan support. So sponsored by Senator Cardin and with support from both Murkowski and Collins. So you have bipartisan support there, although the Senate has not acted to vote on the resolution. Okay. But even if Congress did, and then even if Congress did pass that resolution, does it count, right? That would be a question. that would have to be settled and would probably be taken to the courts. But the other question that remains is whether or not those 5 states that tried to rescind their ratification can do so. So states tried for both the 14th and 15th Amendments to rescind ratifications, and Congress basically just forged ahead like that never happened and said, basically, you can't do that, we're going to count your ratification anyway. But in 1980, a federal court ruling in Idaho did say that their rescission of the Equal Rights Amendment ratification was valid. So again, that would pose some questions. So for the moment, right, Congress hasn't tried to change the deadline or hasn't finished trying to change the deadline. The archivist of the U.S., who is the one who has to actually accept ratifications, hasn't accepted Virginia's ratification, so we only have 37. But particularly if Congress decided to act, we might see some more debate and perhaps potential court action on these questions. Some other failed amendments. There were 3 in the 20th century that were successfully proposed, but then were not ratified. So this was a child labor amendment giving the federal government the power to regulate child labor, the Equal Rights Amendment that I was just talking about, and a DC congressional representation amendment that would treat Washington, D.C. like a state for the purposes of congressional representation. So they would get a voting member of the House and voting senators, okay? And then there are a whole swath of other amendments that have been proposed. I've thrown a few up here. These are, again, just a small kind of subset of all of the ones that have been proposed. One there was a lot of talk about in the early 2000s was the Federal Marriage Amendment, which would have created a constitutional limit to sex as between a man and a woman in the Constitution, and that was proposed a number of times in the early 2000s. There was talk of what was nicknamed the Arnold Amendment, which would have made it so that right now you have to be a natural-born citizen, you have to have been born a U.S. citizen to be president or vice president. This would have made it so that you only had to have been a citizen for 20 or 30 years, 20 years, which would potentially have allowed Arnold Schwarzenegger to run for president, which is why it's nicknamed the Arnold Amendment. And then we see attempts to fix some of the things, right, that people are unhappy with, right? So if people are unhappy with campaign finance, particularly in the wake of the Citizens United decision, attempts to amend the Constitution about that. People are unhappy with the size of the federal debt, right? So there have been proposals for balanced budget amendments where the government would have to pass a balanced budget. One perhaps we can talk a little more about at the end. Various amendments to abolish the Electoral College. Whoops, to know that's a move. A human life amendment, right, trying to overcome the court's decision on Roe versus Wade by guaranteeing a right to human life in the Constitution, and some term limit amendments along the lines of what we heard from Dr. Morgan and we'll hear from Dr. White. But my proposed amendment, which like I said I think would probably fail, would be to change the electoral system that the U.S. uses to some form of proportional representation. So proportional representation is a system that is used in much of the world. Basically, the purple countries use some form of proportional representation. And in the most classic form of proportional representation, instead of going and voting for your member of Congress in your local district, right, or your senator in your state, you would go and you would vote for a party. And then, kind of avoiding the gerrymandering issue that we heard about from Dr. Almeida, if a party wins whatever percentage of the vote, it gets that percentage of the seats, approximately, right? So if North Carolina's Republicans win about 50% of the vote, they're going to get about 50% of the seats, okay, instead of 75%. And This has a number of advantages. So one, it is more proportional, right? If it sounded unfair to you that, you know, in North Carolina, the Republicans are winning only 50% of the vote and getting 77% of the seats, right? This would be much more proportional, okay? And also, it tends to lead to more political parties, right? Because right now in the US, if you go and vote for a third party candidate, you kind of feel like you're wasting your vote. That person doesn't have a chance of winning, and so you don't bother to vote for them at all. But here, as long as that third party gets, and it varies a little bit by the rules, but if they got 5% of the vote, right, then they could get a seat in the legislature. And so you're not wasting your vote to vote for those parties, okay? And these are some recent kind of guesses at what having more parties in the US might look like. So one possibility is to split kind of the Republican Party into a Trump Republican Party and kind of a more classic Republican Party, okay? And then to split the Democrats into Biden Democrats and Sanders Warren Democrats. And this poll found that those would actually be almost perfectly equally, have almost perfectly equal support in the electorate. Another recent column in the New York Times by a political scientist, Lee Drutman, proposes 6 political parties. And you can go and take a quiz that they have on the New York Times page, and it asks you about 20 questions about your policy preferences, and then it kind of shows you where you would be in relation to these 6 parties. And I don't have a ton of time, so I'm not going to go into a super amount of detail on these, right? But you can see there would be about 3 Democratic parties, or 3 parties that are now made up of mostly Democratic Party voters, and 3 more Republican-leaning parties. The Patriot Party up at the top would be kind of your Trump party, all right? The Progressive Party down at the bottom left would be kind of your AOC, Elizabeth Warren type party focused on social justice, equity, and progressive economics, okay? And so I think that having more parties would probably be good for US democracy, in that it would help reduce the level of polarization and the sense of kind of zero-sum competition that we have in our current political system, right? Any win for the Democrats is automatically a loss for the Republicans. Well, if you have 6 parties, it's not that obvious that that's the case. And also, there are a lot of people who say, neither one of those parties represents me, right? Well, if we had 6, maybe you would feel more represented by one of the political parties. So I do think there are probably some other electoral system changes we could make that might be more likely to actually happen. But I thought I'd throw this one out there as a potential amendment. And now I'll pass off to Dr. White.
And if I may, for that government to get anything done, those 4 groups at the bottom, like 3 of them have to decide, if 3 of them combine, form a coalition, you get 51%, and then you could actually pass legislation. So would it be Trump Republicans, Party Republicans, and Biden Democrats sort of working together, or would it be the lower 3 together? It seems like that's how it would fit ideologically. Let's see. So quick getting back, we just have a little bit more time. I just wanted to get back to amending the Constitution. You might recall that you figured out that that bottom left corner has never been used. Okay? All 27 amendments started with 2/3 of both houses of Congress. I wanted to let you know that it's not because people aren't trying. This is I've seen, they tend to be more conservative organizations that are pushing for this to happen, to have state legislatures request a national convention. Some are more specific than others. I've seen one with respect to term limits. Other people are not so excited about it. This is Common Cause saying this would not be a good idea. But probably the best advocate or the best ally with Common Cause is Justice Antonin Scalia, who, when asked about having a national convention, said, whoa, who knows what would come out of it? Okay? And that's a good question. Who knows what would come out of it? That's what people are afraid of. You go in with one idea and say, hey, while we're there, why don't we, come up with about 7 other proposals? So that's what has people worried. So what I just wanted to touch on, my proposal is something you've heard about before. It's term limits. And I want you to think about your own suggestions, because that's what we're going to do at the very end. See if you have some proposals we can chat about. Most proposals for term limits have been for 12 years. So you would serve 2 terms in the Senate or 6 terms in the House. The problem with that, one is it's anti-democratic, because in the democratic sense, as long as you like people and want to vote for them, and if you have competitive elections, why not keep putting them in? Okay. When some states finally did pass this, the Supreme Court ruled in 1995 that no, states can't do anything with respect to federal elections. So there are states that have term limits, but there are no term limits on federal elections. I'm thinking 30 years would be good. Now, some of you, term limit people are like, oh no, that's garbage. But I like that because with 30 years, so it'd be 5 terms in the Senate and 15 terms in the House. First of all, it's more democratic because you keep getting people to run, and if they want to keep them, they can. Members of Congress get some expertise, okay? So they learn their job and they get better at things. And so I think that's advantageous. And I might remind you that South Carolina has done very well without term limits. Strom Thurmond and Fritz Hollings together, have about 90 years of Senate experience at one time, and were true the most senior senators in the U.S. Senate. The downside for term limits that people argue is that when you have term limits, it gives power to staff and to lobbyists, okay? Because when a new person comes in and says, I don't know what I'm doing, oh, well, I'll hire someone that just worked for the last congressman because they know what they're doing. And so then they come in and they have all the knowledge, and then they might be able to influence things, and that's not the person you voted for. So that's the downside to that. So anyway, I just wanted to throw that out there for you.